Terrified that one piece of paper could wipe out your future? In 2026, the denial risk rule means zero tolerance for mistakes. One small error now can mean instant denial. No second chances. I'm Tim from Immigration Updates Hub, and this is your survival guide to a perfect application. Imagine this. You spend months preparing your immigration paperwork. You triple-check the dates. You save every pay stub. You finally mail the packet. Then, weeks later, you open your mailbox and see a notice. Your application has been denied due to missing initial evidence, or worse, rejected due to incorrect fee. All because of one unchecked box, or a $10 mistake, or an outdated form you downloaded last year. That is the reality many people are waking up to in 2026. If you're watching this with an I-485, I-765, or any other application sitting half-finished right now, and you're wondering, should I even file this? Is it worth the risk? Stay with me. Take a slow breath in and out. This video is going to calm you down, give you clarity, and more importantly, give you a step-by-step plan to protect your case in this new, much harsher environment. By the end, you'll understand what really changed in 2026. Who is at the highest risk of denial? The top mistakes that are killing cases right now. How to prepare a one-shot application that can survive this system. And what options you have if something goes wrong. Do not click away halfway. One detail you miss could be the exact detail that saves or sinks your own application. Hello everyone, I'm Tim, and welcome back to Immigration Updates Hub, where we focus on facts, not fear, and help you navigate U.S. immigration with clarity and calm. Let's get straight into it. First, we need to kill a few rumors that are spreading like wildfire. You've probably seen videos or posts saying, USCIS has stopped approving green cards. There's a secret blanket ban on all visas. Nobody is getting through anymore. That is not what is happening. The U.S. immigration system is still operating. USCIS officers are going to work. Cases are being processed. Green cards, work permits, and visas are being approved every single day. But, and this is the part you absolutely must understand, the rules of the game have changed. It's not the law of who qualifies that has drastically changed. It's how unforgiving the system is when your application is not perfect from day one. Think of it like this. In the old environment, if your packet was like a half-finished puzzle, USCIS might say, "You're missing a few pieces. Send us what's missing and we'll keep going." In 2026, if that puzzle isn't clearly complete when they open the envelope, many officers are now allowed to say, "This doesn't prove eligibility. Denied." No warning, no second chance, no, "you forgot something." This is what people are calling the denial risk environment. Let's break down what that actually means. For many years, when you made a mistake, maybe you forgot a tax return, you were missing a birth certificate, you accidentally left out a signature, USCIS would often send you a request for evidence, RFE, or a notice of intent to deny, NOID. That was the safety net. It was the government saying, "You might qualify, but we can't approve you yet. Fix this and we'll keep your case alive." In 2026, under the new adjudication standards, that safety net has been pulled back. Officers now have broader discretion to deny a case outright if the initial submission does not clearly establish eligibility. That means, if you leave a critical section blank, if you use an outdated edition of the form, if you don't include the required initial evidence listed in the form instructions. The officer is not required to give you a chance to correct it. They can simply say, "This doesn't meet the standard. Denied." So the burden has shifted in a very important way. The burden of proof has always been on you. Now, the burden of near perfection from day one is also on you. This is being sold as a way to clear backlogs by quickly removing weak or incomplete cases. But in reality, it's also sweeping up honest people who are making simple human mistakes. So who is most at risk in this 2026 environment? Let's be very honest. The people in the danger zone are those filing completely on their own, with no professional review. Those copying someone else's old packet. "My cousin used this form in 2024, I'll just change the names." Those relying on forums, WhatsApp groups, and random YouTube videos from last year. Those using forms they downloaded months ago and saved on their computer. If that sounds like you, pay attention now. Because as of January 1st, 2026, several major forms, including the I-765 Work Permit and the I-485 Adjustment of Status, have new additions. If you downloaded an I-765 in mid-2025, printed a stack of I-485s last year and put them in a folder, and you mail those old versions today, your case can be rejected at the lockbox or even denied later, without anyone ever giving you a chance to fix it. Let me give you a quick, realistic example. Imagine Maria. She's married to a U.S. citizen. She qualifies for a green card through marriage. She's been here legally, no crimes, everything clean. She fills out an I-485, but it's the old edition she printed months ago. She forgets to sign one page where it asks for a handwritten signature. She misses one tax return for her spouse. Under the old system, there is a good chance she would have received an RFE. Please submit the missing tax return and sign this page. Under the 2026 standards, her entire application may be denied. Wrong edition, missing signature, missing required initial evidence. 3 fixable mistakes, 1 devastating result. That's the denial risk environment you are filing into now. Let's talk about the top denial triggers we are seeing or expecting under these stricter policies, especially for self-filers. If you stay with me through this part, you can avoid the mistakes that are ending a lot of cases. Denial trigger number 1. Wrong edition of the form. Every USCIS form has an edition date printed at the bottom. USCIS.gov also shows the current edition they accept. If what's printed at the bottom of your form does not match the edition date on the website, you are asking for a rejection before the case is even opened or a technical denial later on. Always print forms directly from USCIS.gov right before you file. Never rely on a saved copy from months ago. Denial trigger number 2. Missing or incorrect signatures. Sounds simple, but this one kills more cases than you'd think. Common signature mistakes. Applicant forgets to sign one of the pages. Petitioner, the sponsoring spouse or employer, forgets to sign their form. Interpreter or preparer signatures are missing where required. Digital signatures used where USCIS requires ink signatures. In 2026, this is no longer, "Oops, we'll send you an RFE." This is case not properly filed or not approvable, denied or rejected. Denial trigger number 3, wrong fee, wrong payment, or old fee amounts. As of January 1st, 2026, certain fees have changed. For example, for some categories, the I-765 fee has gone from $550 to $560. If you follow an old blog post that says $550, copy your friend's 2025 check, or don't check the current fee schedule, and you send $550 when the correct fee is $560, your entire package can be sent back or refused. In the old environment, maybe they would have given you a chance to fix it. In this one, that $10 mistake can delay your case for months or cause you to miss a deadline and fall out of status. Always verify the fee on the official USCIS website or the G1055 fee schedule on the same day you prepare your payment. Denial trigger number 4, missing initial evidence. This is a big one. USCIS distinguishes between initial evidence, the basic required documents listed in the instructions, and additional evidence, extra proof they might ask for. In 2026, if you don't send all required initial evidence up front, they may simply deny without warning. That includes things like birth certificates, marriage certificates and divorce decrees, proof of U.S. citizenship or residency of the petitioner, tax transcripts or returns for sponsors, status documents, I-94, visas, approval notices, required photos, required forms like the I-864 for family cases. If the instructions say it's required, treat it like oxygen. Your case can't live without it. Denial trigger number 5, inconsistent information. Another silent killer is inconsistency. Example: your name is spelled one way on the I-130 and another way on the I-485. Dates of entry, marriage, divorce, or employment don't match across forms. Your address history doesn't line up with your employment history. Answers contradict things in your old applications or records. These inconsistencies can trigger doubts about credibility, requests for more evidence, or, in this tougher environment, an outright denial. Before you file, read your entire packet as if you were the officer. Ask, does this tell a clear, consistent story? Now let's talk about something that's frightening many people: country-based delays and extra scrutiny. There is a policy memorandum, PM 602-0194, that has implemented a hold and review procedure for nationals of certain high-risk countries identified by the Department of Homeland Security. Here's what that means in practical terms. If you are from one of those countries, your case is not automatically denied. But your case is more likely to be paused while extra security and background checks are carried out. Your processing time may be longer than someone from another country with a very similar case. So if your friend from country A got approved in 6 months, you from country B are still waiting after 11 months with no decision, it may not be that you did anything wrong. It might be the impact of this policy and the extra vetting. It is unfair for many law-abiding people, but knowing this helps you interpret delays instead of spiraling into panic. Let's come back to fees, because they're a hidden trap in 2026. We've already mentioned the I-765 changing from $550 to $560 for certain categories. There are also changes affecting some asylum-related applications and temporary protected status TPS-related filings.
The main danger is not the size of the change. It's that most people rely on old blog posts, screenshot fee charts from last year, or assume this is what my friend paid, so it must be right. Then what happens? You write a check for the wrong amount. Your money order is for last year's fee. You forget an additional biometrics fee for your category. USCIS receives the packet, and instead of asking you to fix it, they reject it at intake or delay everything while they return it to you. If you're on a strict deadline, like renewing a work permit before it expires, that can mean a gap in work authorization. You suddenly can't work legally for weeks or months. Your employer has to take you off the schedule. So again, never assume yesterday's fee is today's fee. Always confirm using USCIS.gov and the G1055 fee schedule right before you send your package. Now let's talk about travel, because this is another area where 2026 is risky.
We've seen increased scrutiny at ports of entry and new travel restrictions under Presidential Proclamation 10998. If you are a permanent resident, green card holder, in general, these bans are not aimed at you in the same way as they target visitors or applicants. You still have the right to live in the U.S., but you still need to be careful with extended trips. Long absences can raise questions about whether you've abandoned your residence. If you are here on a temporary visa or have a pending application like adjustment of status, change of status, or certain work permits, you need to be extremely cautious about leaving the U.S. right now. Imagine this scenario. You apply for adjustment of status inside the U.S. Your I-485 is pending. You fly home for a wedding or emergency.
While you're gone, your case is denied because of a paperwork error or a new policy takes effect. You try to return, and now you no longer have a valid underlying status, and there's a denial on your record. You can find yourself stuck outside with no easy way to get back in. In this climate, for most people with pending applications, the safest move is do not leave the U.S. without talking to a qualified immigration attorney first. Understand exactly what documents and authorizations you need, like advance parole in some categories, and exactly what risks you are taking. So what can you actually do to protect yourself? Let me give you a practical 2026 safe filing checklist you can follow before you mail anything. You may want to pause the video and write these down. Step 1. Get your timeline clear. Know your status expiration dates. Know any filing windows or deadline. Don't wait until the last minute. Rushed filings lead to mistakes.
Step 2. Download fresh forms from USCIS.gov. Go to USCIS.gov. Search for your exact form number, for example, I-485, I-765. Download and print the form directly from the website. Check the edition date on the website and make sure it matches what's printed at the bottom of your form pages. If it doesn't match, throw away the old one. Print a new copy. Step 3. Read the instructions once, all the way through. Each form has its own official instructions. Download those as well. Read them from start to finish at least once before you start filling out the form. Highlight every place it says you must include or you are required to submit. This is your blueprint for required initial evidence. Step 4. Create a personalized evidence checklist. Based on the instructions, make your own checklist. Identity documents.
Civil documents: birth, marriage, divorce, adoption. Status documents: I-94, visas, approval notices. Financial documents: tax returns, W-2s, pay stubs, bank statements. Relationship evidence for marriage cases, etc. Commit to this rule. If it's listed as required, I will not send my application without it.
Step 5. Organize your packet clearly. Use a cover letter or table of contents that briefly explains what you are applying for. Group evidence into labeled sections: identity, status, financial support, relationship evidence, etc. Use tabs or separators if possible. Your goal? Make it easy for a tired officer to see that your case is complete and well documented. Step 6. Triple-check all signatures and dates. Before you assemble the final packet, check every page that requires a signature. Make sure the applicant, petitioner, sponsor, interpreter, and preparer, if any, have signed where needed.
Make sure dates are correct and consistent. Missing signatures are embarrassing reasons to lose a case in 2026. Step 7. Verify fees the same day you prepare payment. Check the current fee for your form on USCIS.gov or the G1055 fee schedule. Confirm whether you also need a biometrics fee. If paying by check, make it payable to U.S. Department of Homeland Security, spelled out. Match the numeric and written amounts perfectly. Sign and date it correctly. Do not rely on last year's fees or someone else's experience. Step 8. Make a complete copy of everything. Before you mail, scan or photocopy every form and every document you are sending. Keep this copy organized. You may need it to respond to questions or prepare for an interview later. Step 9. Use trackable mail. Don't just drop your future into a random mailbox. Use USPS Priority Mail, FedEx, UPS, something with tracking and delivery confirmation. Keep the tracking number and confirmation safe. Step 10. Consider a professional review. If you are confused at any step, have a complicated history, or are from one of the countries subject to extra scrutiny, strongly consider having a qualified immigration attorney review your packet before you send it. It can cost far less than losing your filing fees, your time, and your peace of mind. Now, what if, despite all of this, your case is denied? You are not powerless. The government can't secretly erase your basic legal protections. If you receive a denial notice, read it carefully. Look at why they denied you, missing evidence, incorrect legal basis, credibility, etc. Look for any mention of appeal rights or motions and note the deadlines. In many cases, you may have options like a motion to reopen, if new evidence or corrected evidence can fix the problem, a motion to reconsider, if the officer misapplied the law or policy,
and appeal to a higher administrative body, if allowed for that type of case. These options often have very short deadlines, sometimes 30 days from the date on the notice, so you cannot ignore a denial and deal with it later. If you're denied, do not panic. Do not disappear. Do talk to a knowledgeable immigration attorney as quickly as possible. Sometimes a denial can be fixed. Sometimes you may need a different strategy entirely. But you need professional guidance to know which is which. Let's bring this all together. Here's what I want you to walk away with. The system in 2026 is stricter, not shut down. The old safety net of RFEs and NOIDs has been pulled back. Many cases will not get a second chance. Small mistakes, wrong form addition, wrong fee, missing signature, missing initial evidence, can now kill a case that would have been fixable before. Nationals of certain countries may face extra delays in security checks under policies like PM 602-0194. Travel is riskier for people with pending cases or temporary visas, especially under measures like Presidential Proclamation 10998. You still have rights. Motions, appeals, and legal protections exist if something goes wrong. Most people who honestly qualify, who tell the truth, and who file complete, accurate, and up-to-date applications are still being approved. This is not the end of your dream, but it is a time when sloppiness, rushing, and relying on rumors can destroy it. Focus on what you can control. Your forms, your evidence, your accuracy, your timing, your choice to seek professional help if you need it. Let the facts, not TikTok rumors, guide your decisions. If this video gave you clarity and a solid plan, do 3 things for me. 1. Subscribe to Immigration Updates Hub and turn on the notification bell so you don't miss future updates. 2. Share this video with at least one person you know who is applying for a visa, work permit, or green card this year. It might literally save their case. 3. Comment below with your biggest concern about filing in 2026. I read as many comments as I can, and your questions help me decide what videos to make next. You are not alone in this. We will get through this year with information, preparation, and patience. Thank you for spending your time with Immigration Updates Hub. I'm Tim, and I'll see you in the next update. Terrified that one piece of paper could wipe out your future? In 2026, the denial risk rule means 0 tolerance for mistakes. One small error now can mean instant denial. No second chances. I'm Tim from Immigration Updates Hub, and this is your survival guide to a perfect application.